Okay, so here's what happens in a collection case like this. This is a credit card collection case. It's been filed in the Court of Common Pleas in South Carolina. And so you may have been paying on this debt some, you may not have. The plaintiff in a case like this has to have the papers delivered to you and handed to you or someone of age at your home. Okay, so they could really serve it on either one of you. There's a practice that has developed where the sheriff's office in many of the counties in this state, they have a civil division, okay, and that's who serves papers for civil cases like this. Now, what happens sometimes is the sheriff, rather than doing what they're being paid to do and coming out to your house and handing you the papers, which they're typically paid like $25 to do, they send you a letter that looks very official, and it's from the sheriff, and you're scared not to do what it says, and it says, we have papers, you need to serve on you, you need to come to our office and pick them up. And you're afraid that it's going to somehow be against the law or something to not do that. But, you're disabled, it's difficult for you to get out, perhaps, and you have the right to call the sheriff and say, I can't come pick up the papers. You're going to need to bring them to my house if you want me to get a hold of them. So I just want to say that so that you'll know for the future if this happens again, and this may not happen to you again, it doesn't sound like, but if it did, you need to know that they're paid to bring those papers to you. But they still often are maybe uniformed, or they have a badge or something like that. So that's the first thing I would mention about that. Sometimes it can be scary, and it worries you that maybe there's some criminal charge involved. And I can assure you that it's not a crime to fail to pay this debt. Okay, so let me say that first off. Often debt collectors will threaten that. They'll say, well, you're going to go to jail if you don't pay this, or we're going to garnish your wages. Or, in South Carolina, they can't garnish your wages for a debt. And as in typical cases like this, the complaint against you, has 5 or 6 things that it says. It says what county in South Carolina you live in. It says what, where this company is. And then it says that they own this debt of yours. And they say kind of where the debt comes from. And they give an amount that they say is owed. The issue here in this lawsuit is not why you haven't paid, or not whether or not you can make payments. This is simply a lawsuit to establish that you owe this money and how much you owe. So lots of times what happens is people want to explain why they haven't paid, or they want to explain why the amount has gotten so high, or they want to say, well, I know I'll be able to start paying, in 2 months, or I'm getting ready to start a new job and then I can pay. But this lawsuit is only about whether or not you owe this credit card account and whether or not they have the right to collect it from you. Typically, you would respond to a complaint like this with what we call a general denial. And that's a response that our South Carolina Rules of Procedure allow you to file in response, because what you're really saying to this company is prove it. You say that you own this debt that I owed. You're saying it's this amount of money. You're saying that I still owe it. Prove it. And you have the right to require them to come to court and prove that what they say in this complaint is true. First of all, the statute of limitations on a debt like this is 3 years. So it's always important at the outset to know whether or not you've made a payment in the last 3 years. So if you haven't made a payment in the last 3 years, then that is a defense to this lawsuit, because they've waited too long to sue you. Okay? And there can be some other types of defenses like that. For example, the creditor that's suing you is not who you originally had the credit card with. Okay? It's a debt buyer who has bought this credit card debt along with a whole lot of other credit card debt. that's sometimes almost indistinguishable one from the other. And they essentially transfer the accounts through a computer, and they pay pennies on the dollar for the account. So just as an example, if you owe, they say you owe $4,000, well, it's quite possible that when they bought your or your credit card debt, that they paid $40 for it, for the $4,000 debt. So anything that you pay them, in this example anyway, anything that you pay them above $40 is just money in their pocket. And so that's their business model. That's how they make money. So lots of times people will say to me, well, I know I owe this debt. This was my credit card, and, I really want to pay it. But what you don't always realize is that the money that you might be paying towards it, number one, will never pay it off, most likely. And number two, is really not going to the original debt that you made. It's just a way for these people to make money. And that's why they call them debt buyers. They buy the debt, and then they try to get whatever money they can from you in whatever way that they can. So one of the other defenses that we often see is that they may not really have bought your debt. They may not really have the right to sue you for this debt that they're suing you for. And so that's a defense that, it's important to go through and say, okay, is this a credit card that I had? Does what they say is owed here bear any resemblance to what I'm thinking this credit card had owed on it? Because very often, this is another defense, that maybe this is a credit card that you have, and maybe you have paid within the last 3 years, so none of those things apply. But they may have charged you a bunch of fees that they weren't really allowed to charge you. And that can sometimes run that debt up to where lots of times people will come in and say, well, I know I owe $1,500, but now all of a sudden they say it's $3,500 and I don't owe that much. Well, that's a defense to this case, to say, yeah, I had this credit card, and if you can prove that you have bought this debt and you have the right to collect it from me, then we got to get the amount right. It's a defense to this case if you have paid on this debt and they haven't given you credit for it, or if they've added charges that they shouldn't have had. So that'd be part of defending this case. I want to mention one other defense that you may have to this lawsuit. And you may or may not have it in your case, but in talking about payments being made and settlement and that sort of thing, there is something that is called in the law accord and satisfaction. And what that means is you come to an agreement with them that a particular amount is what is going to be owed and that you're going to pay that off in a certain way, and then you pay that off. And we often see people who come in and they've still been sued, even though they came to an accord or an agreement, and then pursuant to that agreement, they satisfied the debt by making the payments as they promised, and that's why they call it accord and satisfaction. So that's something that we also need to explore, so I just wanted to mention that before we went on. So those are the kind of things that we're looking for in defending a lawsuit like this. So what happens then in a case like this, ultimately, is we would respond to the complaint with some of the defenses that we just talked about. And then we would use some tools that we have called discovery to find out from this creditor whether or not they really own this debt of yours. If they can really prove what is owed by you, if anything, because that's something that they've got to prove to begin with. And then if they can prove that a debt is owed, they're going to have to prove how much. And any evidence that you have of payments that you have made on it, are going to be crucial to that. Now, ultimately, if this is a credit card of yours and you do owe something and we can get the proof to where we know exactly how much you owe and what we think you owe, you may still get a judgment against you for that amount, okay? But just because they get a judgment against you does not mean that you're required to pay it. If you're on Social Security, you just may not be able to pay it. And over the years of this debt this credit card that you've had, you've purchased things and used the credit card for various purposes, but you've also paid quite a bit of interest over the years. So they've made plenty of money on you over the years. And so I just say that to emphasize that if you don't have the money in your budget to pay towards this debt, that's okay. Okay? They can't put you in jail for not paying this debt. Now, but the next step, I do want to make sure that you understand. If they get the judgment against you, they may call you up and say, oh, you have to make payments, you have to pay this, and you don't. But sometimes they take the next step, which is something called an examination of assets. And this is where they want to bring you into court and have testimony from you about what your assets are, to see if there is something that you own that could be sold to pay this debt. That's not going to be a concern here. If anything that you have is what we call exempt from being sold to pay a judgment. And we have certain exemptions in South Carolina, and those are on our website. You can find them there. One other thing I wanted to say about these supplemental proceedings where there's an order to appear for examination of assets. There is one preliminary step to that happens that also involves the sheriff again, okay? And the rules of civil procedure here in South Carolina require that the sheriff serve on you first something called a notice of levy. And this is where the sheriff is supposed to determine if you have any property that could be sold to satisfy the debt, okay? Typically, what they sometimes do is either come to your door and say, here's this paper I'm serving on you. You need to tell me what assets you have. Sometimes they'll give you or send you a letter or a form that says, here, fill this out and tell me what property you have. Do you have a house? You have, money in the bank? Do you have a car? And so forth. And what are the value of those things? And so usually what you can do in your situation where everything's exempt and you really don't have any assets, you can file a notice of exemptions with the court and provide that to the sheriff also. And that's something that I would suggest that you do in that case, if that happens to you. The sheriff is required to make some kind of determination, but if they don't find any property available, then they send this notice of levy back to the creditor's attorney, and it's stamped with the words nulla bona. And what that means is they found no property. Okay? So this order to appear for examination of assets can't be issued until that nulla bona notice has come back from the sheriff. That's part of the required documentation for this creditor attorney to get that order to appear. So I do like to warn people about that as well, because it's always scary when somebody with a badge comes to your door and you worry, oh gosh, I better pay this or I'm going to jail. And that's just not the case. The only thing you're required to do is provide appropriate information, and if you're ordered to appear at the court, to go and do that. So what happens is, if they pursue that process of trying to collect the judgment from you, then they will serve you with papers, and it does have to be personally served on you, the person with the judgment against them, because it's an order to appear. So the sheriff can't call you and tell you to come get it. If they do, you shouldn't go get it. You should make them come bring it to you. And this is an order to appear, so you do need to actually go to court when that order says that you should be there. What happens at those hearings, though, sometimes is the collection attorney for the creditor, tries to get you to agree to a payment plan before court ever starts. Okay, And under our law in South Carolina, you're not required to do that. We have a law that against garnishment of your wages or anything like that for a judgment like this. So, or if you have Social Security, that cannot be garnished for this judgment. So your income is protected from this, all right? But not everybody knows that. And so if you agree to a payment plan like that, then the attorney will just get you to sign a consent order or something like that. And then you do have a court order requiring you to pay. And that's not a good thing, especially when all of your income and your assets are exempt from payment. So we have more information about the details of that, but I always think it's important to warn people about that sort of next step. Now, I also want to mention that if you do have to go to the court and you provide all your information that you have no assets to pay this judgment with, everything's exempt, then ultimately what the judge will do is issue an order that says there are no assets to pay this judgment.